I am appearing for the petitioner and my lord, Mr. Tanmoy Mohan to appear for the other side. I have taken his consent. Can it be taken up after 1 week, my lord?
35.
35.
The request made by Mr. T. Chaudhary. It stands deferred to be listed after 1 week. Is submitted consent of the council for the response.
Yes. I am deferred.
In respect to item number 37 and 38, I have the instruction to withdraw this through this petition.
Mr.
And we allowed to withdraw with liberty.
UK Goswami, learned counsel appearing for the petitioner in item 37 and 38. On instructions, submit that the writ petitioner does not wish to press the petition any further. Accordingly, the same stands dismissed on withdrawal with liberty. Interim orders, if any, stands vacated pending ayes or
I document on item number 48, Mathun Mehta, my lord, supplementary list. My lord, I want to file an additional affidavit, my lord, here, my lord. My lord, kindly allow me to file additional affidavit, my lord, and taken up this matter next week, my lord.
Item 48 at the request made by Mr. M. Koikiel and
Can it be, my lord, taken up on 21st, my lord?
to be listed after 2 weeks? You file
No.
the
In the meantime, I will file, my lord. Urgency is there, my lord.
2 weeks,
No, my lord, next
1
week.
week.
Next.
He
21st,
filed-
my lord. It will be.
Be listed next week, allowing him to file an additional affidavit. List accordingly.
Obliged, lord.
May it please your lordship. Lordship, I pray for listing of a writ petition in admission stage in Friday, lordship.
That I think you have to mention before this court number, the senior court available.
Obliged, lord.
Doctor will take after some time, madam. Both the seniors are listed in court number 1.
Yes.
This is the matter relating to transfer. And on the last occasion, occupier directed me to take instructions. The submission made by my friend on the other side was that he had submitted an application seeking voluntary retirement. Now, Lordship, my instruction is, Lordship, as on date, he has not filed any application for voluntary retirement, but he does make a statement in his writ petition where he says that he wants to go.
Proposing. He's proposing to sub.
It cannot be proposing, Lordship.
No, that is recorded in the order.
Yes, he is proposing if he wants to go on voluntary retirement from next year, that will not have any effect on the order of transfer passed now, Lordship. Next year is
My lord,
too far away.
kindly pass out for some time being, my lord, for time being.
Yes.
Time being.
Lordship, in the series item number 18 and 25, I have 2 meters.
Yes.
Lordship, Mr. VI is late on the court. Kindly pass over for the time being.
All matters we can pass over.
My lord, I was directed to obtain instruction, but I have not received. My lord, matter may be taken up next week, my lord.
All right. Mr. T.C. Sutia, additional senior government
Yes,
advocate,
go ahead,
will
huh?
further time to obtain his instructions list after 2 weeks. Mr. M. Khan appears for the writ petition.
Obliged.
Obliged.
40. Yeah. Yes,
Commissioner has two grounds to challenge the transfer order. One, that he was not keeping well and that he would be submitting his voluntary retirement for the next year. Under SGI was requested to take instructions on the matter.
no, have you submitted? You have not submitted.
Maharaj, what happens is this, Maharaj, he had proposed a retirement for the December 2026. What has come now is that we can submit a voluntary retirement only 3 months prior to the date we want to retire. Take our retirement is what I have understood on our last discussion. Within a 3 months period, I do not know whether it is conducive for him.
That we don't know. You are in service unless you retire or resign. The transfer is an incidence of service.
Is an
Unless you show that
Otherwise, Maharaj, on my grounds, may I just pray that if they can reconsider my representation which has been filed.
where is that represented?
The rejection, Lordship would find at page 31,
Which is already rejected.
already rejected once.
31. 31 appears to be a standing order. 30. 30.
The page 29, madam. Copy of the application perhaps was not retained by him.
Already rejected. What more can be done?
And that part was not taken into consideration.
Which part?
That I would like to.
Do we pass a speaking order here?
No, no, not a speak.
So there must be something indicated in some file.
Lordship
can
may
take
fix a time frame, we'll pass a speaking order within 7 days.
Then we'll have to interfere with this order, or we'll have to direct you to revisit.
Apparently, this does not incorporate the reasons.
No, therefore, we are asking you, this is only
Yes, yes,
an indication some order has been passed.
yes, yes.
Whether such reasons are there in the file.
Oh, Lordship can direct me to bring it on record. Because-
In which case you will have to not give effect to the interim, the transfer order.
Till the next day.
All right. Yes. Heard Mr. R. Mazumdar, learned counsel for the petitioner, Mr. R. K. Dev Chaudhary, learned DI, appearing for the respondent. The petitioner is serving in the
Central Recruit.
which is
CRPF.
CRPF, and he is posted in Silchar, Kachar. So the petitioner was sought to be transferred by the respondents. Where is the transfer order?
Well, at page 21. Prior to that, I had filed a representation at page 19. Prior to the transfer order, when we asked for options. Page 19 is my
Transfer order dated 24/1/2025. In respect of several personnel serving in the CRPF, including the writ petition. Stop name of the writ petitioner appears in serial number 220. It is the case of the petitioner that he had submitted his representation before the authority seeking some accommodation so that he may prefer his application for voluntary retirement stop. However, his representation stood rejected by order dated 31/3/2025. So the transfer is to take effect from 1st of April 2025. Is it struck off?
well, no.
He's still there.
No, I was told on the last occasion that movement order has been issued. Movement order itself does not strike him off.
No,
He's
has he
only-
moved out or not?
No, he has not. He's there.
It is submitted that movement order pursuant to the transfer orders issued have also been issued by the respondent authority. However, petitioner has not yet joined in his new place of posting. So the limited prayer before the court by the writ petitioner is that his representation seeking to file the representation seeking further time and not be transferred out of his present place of posting, permitting him to file an application for
Lordship, that is, he is there in pursuance of this honorable court's last order. Lordship. In view of the last order, we have asked him to remain here.
no, his prayer before the court is for retention in
Yes.
silture. That is what we are recording. His prayer before the court is that he should be retained in silture in his present place of posting and be permitted to file his application seeking voluntary retirement. So, however, that aspect of the matter was not considered and the representation was simply rejected. There are some standing orders. that-
Yes, my lord, that is at page 30 onwards.
Where is the
Page 34 is the terminal posting part. Page 34, clause 6 at the bottom.
referring to the standing order number 4 of 2022 dated 27/9/2022 issued by the Director General CRPF New Delhi. The learned counsel for the petitioner draws the attention of the court to clause number 7 within bracket Roman 6, which provides for terminal posting within courts. Under the terms of, in terms of the said clause, officers or officials or personnel who are due to retire within 2 years to be reckoned from the cutoff date may be considered for a terminal posting to his place of preference or to a nearby place, station, region covered by overnight journey by train, provided he was not posted there in his previous tenure. The learned counsel for the petitioner submit that this clause provided in the standing order has also not been taken into consideration by the respondent while rejecting his representation by the order dated 20. In terms of the earlier order passed, the learned DSBI was permitted to complete his instruction. He, on instruction, submit to the court that no such application has yet been filed by the petitioner seeking voluntary retirement. So, he further submit that the petitioner has made a statement, has made an averment that he seeks voluntary retirement with effect from December 2026, and which, in terms of the rules and regulations, CRPF, is simply not permissible. Voluntary retirement applications are to be submitted 3 months prior to the proposed date of seeking voluntary retirement. Under such circumstances, this being a routine transfer, there is no ground for the petitioner not to comply with the order of transfer. Where having heard learned counsel for the party, it seems that the order dated 31/3/2025 rejecting the representation of the petitioner does not indicate as to whether the ground urged, stated to have been urged to the respondent or were addressed. More particularly, his prayer for filing voluntary retirement. Prayer for further time for filing voluntary retirement. For filing an application for voluntary retirement. Learned, learned DSBI that he may be permitted to obtain his instructions and bring it on record by way of an affidavit. You want to bring it by way of an affidavit?
Yes, Lordship.
By way of an affidavit. Praise for 2 weeks' time.
Lordship.
That view of the matter. Take it. 28,
That's fine, Lordship.
28 May. So,
Me?
till the next date fixed,
28.
the movement order in respect of the writ petitioner pursuant to the transfer order dated 24/1/2025 shall not be given in. It's not 28.
Obliged.
Yeah.
57.
Lordship, in item number 5, my affidavit has gone for vetting. The rest, my affidavit are deputy.
Yes. Are you want to file any reply?
But, they have referred to section 80 CPC in the affidavit in opposition. Reply would not be necessary. Otherwise, the grounds reply would not be necessary. Have it on a date
What
convenient
about
or
the other petitioners? Anyone wants to file a reply?
In item number 30, Lordship, they have not filed affidavit.
Some of the matters affidavit has gone for vetting, Lordship.
You are filing individual affidavits.
Yes. Because the deformities are not similar.
All right. Does it PTC Mr. S.S. Roy submits that the
Gone for vetting.
respondents are in the process of filing affidavit. Most of the writ petitions, the affidavits have been filed. However, some writ petitions, the affidavits are yet to be filed. He therefore prays for further 2 weeks' time
Lordship.
to complete the process of filing affidavits in all the matters where in the matters so desired. Stop. Counsel for the petitioners are also permitted to file their reply affidavit. In the meantime, it is so desired. List on 28. Sorry, 29. 29 May.
only that is not a recruitment process of 2024. In some cases, there are no interim protections. He would ensure it by 29th, we can have the hearing. Otherwise, they fill up the
Respondent
post here.
counsel will ensure that all the affidavits that they propose to file in the writ petitions are filed by the next 8 weeks. Yes,
Interim, my lord, where this will continue.
interim orders wherever passed will continue till the next date.
I'm obliged.
Hailu Buddhu Tatte.
Lordship, in item number 12, Karnataka is not present right there. The matter may be taken up at some time.
Sorry?
In item number 12, Mr. B.M. Deka is candidate election another portion.
Item 12 is a part of the series.
Lordship.
We have fixed it on 29 May.
May it please your lordship. Lordship, my senior is appearing. Lordship, he is currently on legs in court number 1. Lordship, may keep it for time being. Your lordship.
We'll take it up next week.
They are supposed to give the details of the petitioners, madam, where they are working as on date, who is the appointing authority, nothing has been given. 528 petitioners are there, only few appointment letter has been added. And they want, madam, the minimum of the pay scale.
Lordship, we have some instruction.
Yes, sir.
We'll place it after time being. If your lordship may
You
consider.
place it if you have it now.
Lordship, my senior would be better.
It will be listed next week.
But
Request made by the council. Mr. P. Gogoi.
held
Current additional AG appears for Health Department. Next week.
The pleading is already complete, but a stay order is in their favor. Recovery has been stopped. This is recovery relating to some pay fine was imposed, and this is the total of that pay fine. That this recovery is not anything else, Lordship. It is only the pay fine, Lordship, for violation of his.
But the Rafiq Mashi, will it not be applicable?
But Lordship, frequency is if some excess payment is made. Here it is not regarding excess payment, but only because of he had violated the rules, Lordship. I have given the chart at page
There is a
153.
there is a proceeding instituted.
Yes, Lordship. All the cases. 153, I have given the detail of the charges against him. And
Right. We'll
what is
call
the
it, we'll call it up after some time. Let us see. Not
Lordship?
Maybe please, Lordship. Mr. Kane Chowdhury is leading the case. Malad, timing for the matter, Malad.
Yes, time being or next week.
Malad, time being, Malad. Malad, we are ready to argue, Malad. But Mr. Kane Chowdhury is leading the case, Malad. He is on his legs, Malad.
I know, but you should be able to initiate the hearing at least.
Timing for the matter.
Yes,
Next week, Malad, the date may be.
meetings are complete here.
Meetings are completed, Malad.
We'll have it next week.
Malad, date may be fixed, Malad.
But 22nd.
Malad, 22nd.
But in this case, Mr. B. Goswami is appearing lot. He has some difficulties with the law.
Who?
B. Goswami.
In this
Mr.
matter, Lordship, we have completed our part actually, Lordship, but they have to apply the court. And petitioner is going to retire on perhaps Lordship August, Lordship. Lordship, may kindly take up this matter on next Tuesday, Lordship, subject to convenience, Lordship, kindly.
Tuesday, we have too many matters. Right? Too many matters. No point. It don't-
It will try our life, Lord. It's supposed to reach, Lordship.
There's no point fixing that. Have it on 20. 20 August, 20 May.
When
It is
Tuesday.
submitted by council for the response that Mr. P. Goswami,
No, Mr. Goswami.
additional AG, is leading the argument for the respondent. However, has some personal difficulty to adhere to the court. Prayer for adjournment in court. Proper is agreed to by vote count. It's for 20, 20 May.
Obliged. Deeply obliged.
Mr.
Thank you, sir.
N.K. Sharma appears to the petition.
In this case, Rocky was pleased to direct the government advocate to obtain instruction. Lord, Miss MS. Bhattaji. She appeared. She was directed to obtain certain instruction. Whether any report was, my lord, actually prepared or report was acted upon.
For a timing. Not maybe for a timing part of
M. Bhattaji, government advocate. Time being. Yes.
In this case, a record was sent to our office in 2020 to other Diden junior government advocate. I will have to inquire whether record is available or not at this stage. Record would be necessary.
What is the matter? Yes. What record?
Record as per letter dated 22nd August 2023. Record they sent to the government office to the Diden junior government advocate on 8/12/2020.
All right. We'll call it up in a while. Petitioner counsel is not available. We'll just call it up again.
Okay.
Yes. 43.
Lordship, I have received the instruction, Lordship, but that is also not very clear, Lordship. It is stated that the petitioner is presently working, Lordship, in Kodamani Anganwadi Center, Lordship, and she is getting all the pay and allowances, Lordship, whatever is applicable to the Anganwadi worker, Lordship.
No, but he is to be given, there's some, there was some disciplinary proceeding initiated.
No disciplinary proceeding.
Yes.
Only Shopos was issued. I was directed to submit the reply.
Hmm.
Then they, my lord, came with the.
Were you
order.
terminated?
Pardon, my lord?
You were terminated.
Yeah, initially I was terminated, then
Lordship,
interim order.
she is now, as per our.
By virtue of the interim order.
Yes. As per order passed by this honorable court lordship, there was communication from the director lordship and she is immediately been appointed lordship.
No, appointed or working by virtue of the interim order.
Yes, lordship.
When?
But on that count, lordship, regarding the what happened after the show cause, I have not received that particular instruction, lordship.
When are you likely to receive? This is a 2014 matter.
Yes, lordship.
No affidavit has been filed.
Lordship.
We'll have no option but to allow the writ petition, setting aside the order.
Yes, lordship, as she has already been working, lordship may pass an order.
We have to record your submission.
Lordship, that's why, lordship, the kindly fix it on next week, lordship. Most probably due to the ongoing election process, everyone was out of station, lordship. Director and other government authorities, lordship.
Right, we'll have it on 20.
20, lordship.
You
Lordship,
get your instructions.
lordship, on that count, lordship. I shall get.
List again on 20
Lordship.
May, enabling further time to the learned government advocate MSN Bhattacharya to complete the instructions as permitted by this court by the last order taken when Mr. A.K. Purkashta appears for the writ.
Deeply obliged, lordship.
Interim order.
Interim order passed early will continue.
Deeply obliged, lordship.
Petitioners are homeguard, my lord, and their services were terminated, my lord, without issuing any show cause notice. And my lord, and secondly, my lord, the authority which has terminated the services, my lord, it was not the authority under the act, my lord, because it is the Director General Home Guards who is the appointing authority who can terminate. Whereas, my lord, the petitioner were discharged from service by the Superintendent of Police, my lord. The impugn orders are, my lord, at page 45 and my lord, page 43 and 45. Page 43 order, my lord, terminates the services of the petitioner, my lord, and then page 45. And the authority who has issued the order, my lord, they were not the appointing authority. And thirdly, my lord, in the affidavit filed by the my lord, respondents, my lord, they have admitted that the petitioners would have been engaged, my lord, in other departments other than, my lord, the Assam, my lord, under the Assam police, my lord, at page 50 of the affidavit, my lord, they have stated.
Yes, what have
My
they
lord, can
stated?
take page 50.
Hmm.
What I am reading from the last paragraph, my lord, in the said letter, it was also stated that these Home Guard volunteers may be re-engaged, redeployed in any other district or organization for their livelihood. And in that case, there is no objection from this end. However, since the, my lord, impugn orders, my lord, states about termination, for that reason, my lord, they are not even been re-engaged. And further, my lord, the allegations which have been stated in the affidavit, my lord, all those allegations are incorrect because if I, my lord, I have prepared a chart petitioner wise, my lord, and all the allegations are not correct, my lord, because final reports have been submitted in the cases and they have been discharged, acquitted from the charges. My lord. But apparently, my lord, there is no show cause notice, my lord, issued, and they were, my lord, terminated from the services. My lord. The chart which I have submitted, my lord, in respect of each petitioners, the allegations which have been stated in the affidavit regarding involvement in cases. my lord,
Where are their termination orders?
They are home guards, my lord. They are deployed for 6 months only.
One minute.
termination orders, my lord, have been annexed in the affidavit in opposition page 64, my lord.
What is page 43?
Page 43 is the order, my lord, by which their services were discontinued. However, my lord, in the order, the authority has reflected that their services were terminated from, they are terminated from their duties. My lord, it ought to have been discontinued. What happens, my lord, the home guards, they are deployed and they can be discontinued if one department doesn't want. And then, my lord, they can be redeployed by any other department. However, the order reflected, my lord, the word termination, and it was issued by the Deputy Commissioner of Police Administration, whereas the appointing authority of the petitioner is, my lord, Director General Home Guards. This order has been issued without any show cause, my lord. No opportunity of hearing was given, nothing, my lord. Thereafter, my lord, at page 45 is the another impugned order, my lord. Those two orders are impugned. There also, my lord, the order reflects, my lord, that the petitioners have past history of misconduct are hereby discharged from duties. No show cause given, my lord, and in respect of the petitioners involved therein, my lord, who are the petitioners here at serial number 2, 3, and 2, 3, 5, and 6. My lord, I have given a chart in respect of petitioner at serial number 2, Jadav Deka, my lord. There is a final report submitted and he has been discharged and acquitted from the services. So far as, my lord, petition number 5 is concerned, he was discharged without show cause, my lord, and then petitioner number at serial number 8, Rubul Saikia, my lord, in respect of him also, final report has been submitted and he has been discharged and acquitted from charges. So, when these orders were issued, my lord, they were already discharged and acquitted, my lord. Final reports were submitted. Without inquiring those facts, my lord, simply on an allegation that there is a case pending, the petitioner's services were terminated.
Are you government servants?
No, they are appointed under the act, my lord. That is their
You-
affidavit filed by the
You government
respondent.
servants? Is it applicable to an employee under the government or what? Discipline
But
and
the appointment letter reflects, my lord, they are appointed under the Home Guards Act. In the affidavit filed by the respondent, page 49, my lord, at paragraph 4, the mode of appointment is
So
reflected.
does it make you a government servant? That's the question. We're asking for application of the provisions of discipline and appeal rules, isn't it?
No, my lord, I am asking about, my lord, minimum principles of natural justice. Even if I am not a government servant, my lord, the minimum principles of natural justice, my lord, before passing an order of stigmatic termination, I ought to have been given a show cause. And further, the reasons on which, my lord, the termination is made, those reasons are non-existent. I have given a chart, my lord, wherein final
What
reports.
is the status of the cases, criminal cases?
My lord, I have given a chart, my lord. The chart which I have given in respect of each petitioner. Petition number 1, my lord, final report is submitted, he is discharged. FR is submitted, my lord. In respect of petition number 2 also, FR is submitted. petition number 3, my lord, there was no criminal allegation, any involvement of PS case, only for indiscipline he was discharged, but well, again, my lord, no show cause was given. In respect of petition number 4, there is an allegation of gross negligence in connection with custodial death, but again, no allegations were proved nor any charges, my lord, frame against the petition. In respect of petition number 5, my lord, it is just an allegation, my lord, the case is pending, and during the pendency, petitioner was continuing the duties before, even before, my lord, duties before the discharge order. And then petition number 5, again, no, that is for indiscipline, no criminal PS case is there. In respect of petition number 7, my lord, case was withdrawn by the learned APP, and the petitioner was acquitted without framing any charges. In respect of petition number 8, Dil Mohammed, my lord, again, he was acquitted from the said case, continuing duty before discharge, before being discharged without any show cause. And petition number 9, my lord, he is not involved in any PS case, only for indiscipline he was discharged. So, my lord, even the reasons for my lord, discharge are not correct. Most of the petitioners, they have been, my lord, acquitted. FR has been submitted in the PS cases, respective PS cases.
On what basis are you submitting that? What is the law with regard to
My lord,
discharge?
my lord, the law is, my lord, even if it is a case of
What?
my lord, and I'm relying on few decisions, my lord. But paragraph 16, if my lord, there also a similar question had come up, my lord, before the, my lord, before the High Court, my lord. Paragraph 7, that home guard volunteer is not a civil service. It is a volunteer service for which an honorarium is paid. So therefore, my lord, the contention of the respondents was that, my lord, the service rule is not applicable. Discipline and service rule is not applicable, my lord. Then the Honorable Court, my lord, paragraph 12, my lord, the appreciation is there, my lord. Let me read, my lord, paragraph.
Really?
My lord. It is true that as per the observations of this court, in the above referred judgment, the nature of appointment and the status of a home guard volunteer would not be considered permanent, temporary, ad hoc, or daily wage employee, but the services rendered by him are governed by the provisions of the statute, as the Punjab Home Guards organization is constituted under the Punjab Home Guards Act 1947. The 1963 rules have been framed in exercise of powers conferred under Section 9 of the 1947 Act. All the appointments are made to the Home Guard volunteers under this 1947 Act and 1963 rules, which admittedly are applicable to the Chandigarh Home Guards. Merely because they are volunteers does not mean that they do not have any right whatsoever, and the authority, while exercising its powers under 1947 Act and 1963 rules, can act arbitrarily ignoring the provisions of the said Act and rules. In case an employee approaches the court with a grievance alleging violation of the provisions of the above act and the rules, this court, in exercise of its power under Article 226 of the Constitution of India as conferred, would not be bereft of the jurisdiction and the authority to exercise its power of judicial review. The court may, in given facts and circumstances of the case, refuse or refrain itself to exercise its power to delve into the matter. However, it cannot be said that the volunteers serving the Home Guards organization have no right, so far as their services are concerned, and are at mercy of the officers who may exercise their discretion at their whims and fancies, leaving the helpless volunteers without any remedy. In the light of the above, this court, in exercise of its equitable jurisdiction, would therefore proceed to consider the grievance of the petitioner in the light of his contention that Rule 27 of the 1963 rules stands violated by the respondents, as in the garb of an order of discharge having been worded. So, it is a punishment which has been imposed upon the petitioner for alleged misconduct, that is absence from duty, because of his arrest and registration of a criminal case against him. From the perusal of the Annexure 1, which are notings of the respondents as applied to the petitioner under the Right to Information Act, it is apparent that although these aspects with regard to absence of the petitioner from the duty and his arrest in an FIR registered against him were made the basis for terminating the services of the petitioner to avoid the requirement of fulfillment of Rule 27 of the 1963 rule, which would be attracted
Where is
as
that Davinder Singh's case?
No,
You have not brought it.
no, I have to.
This Punjab High Court judgment is rendered on the premise of the Apex Court judgment.
Yes, my lord.
So you did not bring the judgment.
No, lord.
Yes, Mr. Patia.
Our affidavit, look to kindly see. Paragraph 4, page 49. This was one of the different explicit there. Response number 4, District Commander Home Guards Kamrup, Panikhati, Guwahati has deputed the Home Guards volunteers under Section 10 of the Assam Home Guards Act 47, being the control and administrative authority to the Police Commissioner, Guwahati, for the purpose of maintenance of security duty. The petitioners were engaged for the security duty with fixed amount of 767 per day as duty allowances so as per government notification. In this context, the father stated that 1143 Home Guard volunteers were sanctioned by the government for smooth functioning of the security duty under the Police Commissioner Guwahati. These volunteers were directly deputed by the response number 4, that is the District Commander Home Guards Kamrup, Panikhati. That apart, additional 337 Home Guards volunteers are provided by the response 4 as per direction of the response 2, the Director General of Police, Assam, for the purpose of security duty. It is stated that the Deputy Commissioner of Police, Administration Guwahati, response number 6, requested the response number 4 by memo dated 6/12/2023 with a list of 106 number of Home Guards volunteers not to re-engage or redeploy any of the Home Guard volunteers in the future for various reasons, that is arrest, involvement of criminal cases, unauthorized absence, negligence of duties, indisciplinary act, misconduct, and illegal activities. In the said letter, it was also stated that these Home Guard volunteers may be re-engaged, redeployed in any other district or organization for their livelihood, and that case there is no objection for this end. And further answering the opponent bears to state that the petition number 1, these are the malot, they are involved, petition number 1 involved in the Satgam PS case number so and so, and petition number 2 involved in so and so dispute case, all are involved in the criminal cases. But you kindly see page, the letter, page 57. 57. These are letters, my lord, 6/12/2023, issued by the Deputy Commissioner at Police Administration, written to the District Commandant Home Guard. With reference to subject stated above, I would like to inform you that we have submitted a list of Home Guards 106 in the above reference letter to your good office, requesting to not to re-engage or redeploy in any duty as Home Guard volunteers in future for the various reasons, that is areas involvement so and so, so and so, so and so, so. Now I am directed to request you to again not to re-engage, deploy the Home Guards Police Commissioner Guwahati. However, this establishment has no objection if they deploy the other district. That means, my lord, the data is issued by the Police Commissioner Administration because these petitioners are involved in the criminal cases.
Who appointed them?
These are the, actually they are deployed by the district commandant to the as and when required by the district authority. Suppose police commissioner is required to assist the civil police, so they are deployed by the commandant, district commandant Home Guard. Actually, Home Guard, district commander Home Guard is the controlling authority, and he is sending the 106 number of person Home Guards to assist the civil police officer, and they are involved, my lord, in the criminal cases. Why they will be retained, my lord? That's why this police commissioner, my lord, returned to the district commander Home Guard. This has identified 106 person. They are involved in various cases, so they should not be involved in any case. The Home Guard is involved in the MLA, in the ministry, on district administration, any high officials, because for security of the property and for the maintenance of law and order duty to assist the civil police. If they are involved in the criminal cases, how the police commissioner will retain them? They allow them to continue in the with the police, civil police officers. That's why they have identified the police commissioner in the Kamrup says we have no any objection if the 106 person is engaged in any other district if required. I have no any objection. But my district in Kamrup, Guwahati, we cannot allow them because their cases
No,
involved
no,
in the Guwahati
But,
district.
but if you are terminating or discharging them on some,
Yeah, they are the volunteer service for the 6 months only, alternatively.
maybe, but you are not discharging them for completion of their period of service. You are discharging them on the ground of involvement
Yes, yes.
in indiscipline or criminal cases pending.
Yes, sir.
So should they not have been given an
No,
opportunity?
we request the district commandant.
Uh.
That these are persons are not fit for to be a discharge of Home Guard in the Kamrup district. Under
Now
me.
you are releasing, for instance, a list has been submitted. You are releasing somebody who against whom some
Police
police case was filed, in which the final report subsequently was issued after investigation.
No, my lord, we request the district commandant, controlling authority.
Correct. You request. You or the district commandant authority released him on the ground that there's a police.
Yes, sir. That can be. Why not? My lord, police commissioner, he is under police commissioner Home Guard.
Correct. But in that case, ultimately final report was submitted. What is the effect of a final report?
The final report is submitted, my lord. The police commissioner may not engage them or may engage them, but he requested the commandant, controlling authority. Kindly, this person identified as they involved in the police cases, kindly not to deploy in Kamrup district. They may be in the Tinsukia, Dibrugarh, or whatever may be in the other district. There is no any objection. What is wrong, my lord? This is a request.
Final report was.
That discharge may be, yes, because they are deployed to work under me. So who will discharge? Definitely I will discharge. The police commissioner discharge them. So there's no wrong at all. And these are the chart of 57, my lord. How many persons are discharged like that? So many persons are there. Till date of discharge 2012/8/2016, right from 2016 to my lord, up to 19.
I don't think I can take up the matter. Please come to page 43.
My lord,
Please come to page 43.
Repetition.
Yes, it's petition or affidavit, I don't know. 43.
Repetition 43 is repetition, my lord.
43.
43, order.
Yes, serial
Yes.
number 6.
Yes, sir. Yeah, annex 4 here. 43, reference number so dated 28
Serial number 6.
2021. The disease
Serial number.
Why don't you look into serial number 6?
6. So people have Sri Soumitra Soikia, additional judge, Guwahati High Court. Oh, yes, they are a deployed with lordship. And
He was not the, he is not the petitioner here.
so he is not a petitioner, it is a different
No,
thing.
no.
The
I don't
Guwahati
read.
High Court following Home Guards of Police Commissioner Guwahati now attached with House Guard, State Guard, Office, etc. are hereby terminated from their duties with
Before any
effect
other
from
bench, we
31
don't-
July 20 p.m. And they have been deployed. They have been deployed to more than 6 months as per provisions because they have completed 6 months. The Hawk was deployed to assist Lordship's ballot for House Guard. So his term is expired. That is a different thing. But the
Before any other
petitioners,
bench,
Any
before
other
any other bench.
so I think Mala, there is
No, we have really, do it before any other bench. Matter will be listed
other
before any other bench.
yes. Let it be after 2 weeks.
Whatever the authorities decide,
Yes, ma'am.
the registry decides.
It is not. Yes.
Yes.
I'm like.
Wait, Vijay. Lordship should kindly have this WPC 2135. I think yes.
Yeah.
Now, my lord, if a lordship would kindly come to the memorandum which is at page 86, based on which we are claiming this benefit. Now, if lordship would kindly come to page 87, Roman 6.
Yes.
This was the policy decision of the state. The list of employees appointed under Regulation 3F who have been considered here as an exceptional case and one-time measure for regularization as appended at Annexure A and who have rendered services to the government varying from 9 years to 22 years shall be regularized with immediate effect subject to the condition. So these were the conditions. Now page 89 to 90 are the persons, my lord, who were given the benefit of this regularization. Now, my lord, we were similarly identically placed. We are not extended this benefit. Then, my lord, we approached this honorable court. Then authority passed an order, which your lordship will find at page number 132. Pursuant to order of this honorable court. Now, the operative portion is at page 133. Whereas it was examined in the department whether the following conditions laid down by personnel department for consideration of regularization were made by Purna Sindhu, Mudoy and Pankaj Kakoti, the following are the findings. Whether the candidates are overaged, as overaged incumbents are eligible for consideration of regularization as per the OM. The present age limit is 43 years for the government employment for general category as per the personnel OM, personnel department OM dated so and so and so and so, which is relaxable by further 5 years in case of scheduled tribe, scheduled caste candidate. Age of Purna Sindhu Mudoy and Sri Pankaj Kakoti as on 1/1/17 are 37 years 3 months and 39 years 5 months respectively. Thus the incumbents are not overaged. So one of the ground which was earlier considered was that we are not overaged, therefore we cannot be extended the benefit. Number two, whether incumbents have appeared in APSC test interview, as incumbents who have not appeared in APSC
test interview are outside the purview of the OM. Presently, the advertisement issued by APSC for the post of Inspector of Drugs issued by APSC was cancelled, and it is proposed to issue a fresh advertisement soon. Thus, it is concluded that Purno Sindhu Mudoy and Pankaj Kakuti have not appeared in the APSC test. This is also not correct. Anyway, my lord, we challenge this order, and your lordship judgment is at page number 91, and the operative portion is at 114. These two grounds were dealt by this honorable court. Now, if your lordship would kindly come to page 115. Sorry, Millard, 114, para 13. Upon due consideration of the rival contention as well as pleadings available on record, the short question which is required to be decided by the court is whether petitioner fulfills the conditions mentioned under OM dated 16/3/15. Careful perusal of the OM dated 16/3/15 reflects that there are two conditions which are prescribed. If non-fulfilled, will exclude the consideration of the incumbent. These two conditions are that the incumbent did not appear in APSC test or interview, that there was a case sub judice. So, my lord, this was the point which arose for consideration. Eventually, if a lordship to kindly come to para 15 at page 115. In terms of order dated 33/16 passed in IA, the department considered the case of the petitioner, however, rejecting the same by order dated 25/4/17. In the said order, there are two grounds on this petitioner's case along with others were rejected, namely the petitioner was not overaged and that he did not appear before the APSC test or interview. So, lordship takes note of this. Then my lord will kindly come to para 16 at page 117. Now, I'll read from the last sentence, my lord. Consequently, the objection of the respondent that services of the petitioner are currently under the Medical and Health Recruitment Board regulation, as well as amendment made thereunder, and therefore the tenure of extension of the petitioner's service will be dependent on regulation, cannot be accepted to be a ground to take away the right of the petitioner accrued to the petitioner under regulation 3. The petitioner admittedly has been given several extensions over the years. There is no explanation as to why department considered giving continuous extension without considering the fact that the petitioner did not appear for regular selection process. Government, being a model employer, is not expected to extract the services out of the employees on ad hoc basis for several years without disclosing the reasons, and thereafter refuse to consider sympathetically the case of the petitioner for regularization after having rendered services for several years. There is no dispute to the contention raised by the petitioner that petitioners in so and two other connected writ petitions were considered for regularization, as their names could not be considered earlier because of pending departmental proceeding. The impugn order dated 25/4/17 does not disclose the reason as to why the petition was allowed to continue on ad hoc, and no application for vacating or modification interim order passed by this court, nor has any reason been given before this court as to the failure of the respondent to seek the modification vacation of the interim order passed by this court in the present proceeding. The fact remains that OM dated 16/3/15, which is pursuant to the decision taken by the government at the appropriate legal level, was taken well prior to the coming into force of the Medical and Health Recruitment Regulation 2017 and its subsequent amendment. Under such circumstances, this court is of the considered view the matter will require a fresh consideration in the hands of the government for considering the case of the petitioner for regularization in terms of OM dated so. Government will examine the case of the petitioners as also the contention raised before this court that several incumbents who were regularized, who are given the benefit of regularization under OM dated so, did not fulfill the criteria, but nevertheless the benefit of regularization was conferred. So, my lord, now again on the same two ground, my lord, now our case has been rejected, which your lordships will find at page 128. Same two ground. If your lordships would kindly come to my lord, page number 128, my lord. It starts at page 127. If your lordship would kindly come to page 128, the last subpara towards the bottom. Whereas where the candidates are overaged, as overaged incumbents are eligible for consideration of regularization as per OM, the upper age limit is 43 years of for the government employment for the general category. Well, the same thing which was done in last time, my lord. Then if your lordship would kindly come to page 129, the second subpara, whereas from perusal of records availability is evident, petitioners Purno Sindhu Mudoy and Pankaj Kotoki could not avail opportunity of regular appointment as otherwise available. Then we'll have last but one para in the third sub-para from the bottom. Whereas following the cabinet approval and the government directive by later dated so, Rafiqur Rahman and Satyendra Prasad Borua were initially appointed as research assistant under regulation pay for regularized by the Directorate of Health Service by order dated so as per fulfillment of criteria laid down in the personal OM dated so as no irregularities were found. So, my lord, based on again these two ground, my lord, now our case has been rejected. Now, my lord, I am relying on judgment of the Supreme Court, where, my lord, the Supreme Court has said, my lord, in matters of regularization, my lord, pick and choose has been deprecated. Kindly come to paragraph 7, my lord. In the Constitution, when judgment of this court passed in Umadevi, though the court has held that backdoor entry should not be permitted, it has permitted a one-time measure to be conducted for regularization of services of these employees who had completed service of more than 10 years. Indisputably, appellants herein have completed services of more than 10 years. Even this court in case of Ravi Verma versus so-and-so decided on 13/18 found that the act of regular service of some employee and not regularizing the service of other is discriminatory and violative of Article 14 of the Constitution. Mrs. So-and-so, learned additional Solicitor General appearing on behalf of respondent, has vehemently opposed the petition. She submits that since posts were not available, therefore thereafter group the post has been abolished, the appellant could not have been regularized. We are not inclined to accept the submission on behalf of the respondent. When Chief Commissioner of Income Tax has himself found that 65 persons were entitled to be regularized, the act of regularizing the services of only 35 employees and not regularizing service of other employees, including the appellant, is patently discriminatory and violative of Article 14 of the Constitution of India. Now, the impugned order, my lord, there is a reference to the two persons from the health department who were regularized, my lord. Now, having regularized them, now you cannot discriminate. That is the ratio of this case. Now, my lord, now very often, my lord, we refer to Umadevi, that the latest understanding of the Supreme Court on Umadevi, I'll just place two decisions, my lord. I think that's that. If your lordship would kindly take that Jagos case, my lord. It is reported on 2024 SCC online SC 3826. If your lordship would kindly come to para 18. Para 18 at page 70. The appellants have also established that individuals with lesser tenure or comparable roles were regularized by the respondent. The counsel for the appellant had submitted a seniority list for the employees working as multitasking staff published by the respondent department on 4/3/24, wherein the following employees were part of the staff without required qualification. Then Milord will kindly come to next page, para 19. After referring to the chart, it is evident from the foregoing that appellant's role were not only essential but also indistinguishable from those of the regular employees. their sustained contribution over the extended period, coupled with absence of any adverse record, warrant equitable treatment and regularization of their services. Denial of this benefit followed by their arbitrary termination amounts to manifest injustice and must be rectified. Now, this is important, my lord. It is well established that the decision in Uma Devi does not intend to penalize employees who have rendered long years of service, fulfilling ongoing and necessary functions of the state or its instrumentality. The sage judgment sought to prevent backdoor entries and illegal appointment that circumvent constitutional requirements. However, where appointments were not illegal but possibly irregular, and where employees had served continuously against the backdrop of sanctioned functions for a considerable period, need for a fair and human resolution becomes paramount. Prolonged, continuous, and unblemished service performing tasks inherently required on a regular basis can over the time transform what was initially ad hoc or temporary into a scenario demanding their regularization. So, my lord, Vinod Kumar's decision is cited. Then, my lord will kindly come to the other judgment. Sripal, yes, para 14. Para 14 at page number 16. Now, often, my lord, the reliance is placed on Uma Devi. So, recently, my lord, we have seen quite a few judgments where Supreme Court has explained Uma Devi in very unequivocal terms. The respondent employer places reliance on Uma Devi to contend that daily wage or temporary employee cannot claim permanent absorption in the absence of statutory rules providing such absorption. However, now similar. However, as frequently reiterated, Uma Devi itself distinguishes between appointments that are illegal and those that are irregular, the latter being eligible for regularization if they meet certain conditions. More importantly, Uma Devi cannot serve as a seal to justify exploitative engagement persisting for years without the employer undertaking legitimate recruitment. Given the record which shows no true contractor-based arrangement and a consistent need for permanent horticultural staff, the alleged asserted ban on fresh recruitment, though real, cannot justify indefinite daily wage status or continue their unfair practice. So, my lord, the stand of the respondents as always that Uma Devi does not permit regularization, my lord. So this is not correct, my lord. The position is otherwise. This is only in case of backdoor and illegal appointment, my lord, where there is, of course. Now, if it is now, my lord, the cabinet has taken a call to regularize on fulfilling certain conditions. We fulfill. Earlier round of litigation, they denied us, lordships interfered.
If I understand correct, primary criteria is over age.
Yes.
If you're over age,
yes. Then only I become eligible.
If you're over age, you cannot appear for regular selection.
Exactly.
Therefore,
So self-defeating.
Certain benefits are there, but here on facts, they find that you're not over age.
Yes.
The second question follows that if you
and my lord, after
appear for any regular selection.
yes. No, but yes, this ground was earlier taken, this ground was interfered by your lordship. Now, can they again sit in appeal over your lordship's view? Because the same two grounds were reiterated in the earlier round of litigation, which your lordship said no. You give a fresh consideration. Certainly, lordship will not permit them to sit in appeal over your lordship judgment.
What exactly did we direct?
Yes. Please come to the judgment at page 9. It starts at 91 and page 119, my lord, the operative portion. So after taking note of everything, in fact, at page number 116, my lord, kindly see, your lordship has taken note of the order dated 25/4/17. On top, second line. In the said order, there were two grounds on which petitioner's case, along with others, were rejected, namely that petitioner was not overage and that he did not appear before APSC test or interview. So, lordship had taken note of. Then please come to para 17 at 119. Or I can read, my lord, page 118.
Yeah.
116, my lord, sorry. Please come to page 116. In the said impugn order dated 25/4/17, or in the pleadings, there is no reference to the cabinet memorandum under which OM dated 16/3/15 came to be issued. No material has been placed before the court that the case of the petitioners duly considered at the relevant point in time while issuing the OM dated 16/3/15, along with other similarly situated candidates whose names are found to have been considered for regularization in the list appended to the OM dated so-and-so. Whether petitioner's case was placed before the competent authority for due consideration in terms of the OM dated 16/3/15, and under what circumstances the case of the petitioner was not considered, compelling him to approach this court has not been placed before the court by the respondent authority. What is not in dispute is that OM dated 16/3/15 is pursuant to the decision taken by the government at the appropriate level. OM itself reflects that the views and concurrence of various departments, including finance, judicial, etc., as well as opinion of the then Advocate General were taken into consideration. OM reflects that the views of the department were taken in individual cases. The respondents have not placed before the court that at least insofar as the employees of the health department who are regularized under the health and family Welfare department satisfy the criteria as prescribed, and others who did not satisfy, which may or may not include the petitioners, were excluded from the list of the 3 candidates regularized under OM dated so-and-so. Interim order dated passed by the court also subsists. No application has been found to be filed by the respondent seeking vacation or alteration. Basically, your lordship has taken note of the fact that in respect of the person to whom the benefit of 2015 was extended, whether they fulfill the conditions and that the petitioners do not fulfill the condition, nothing was placed on record.
Yeah.
Now, if your lordship would kindly come to page 118, my lord.
Yeah.
Line about 7 from bottom. There is no dispute to the contentions raised by the petitioner that petitioners in WPC 3767 of 15 and other 2 connected writ petitions were considered for regularization, as their names could not be considered earlier because of the pending departmental proceeding. The impugn order does not disclose the reason as to why the petition was allowed to continue on ad hoc, and no application for vacating or modification of the interim order passed by this court, nor has any reason been given before this court as to the failure of the respondent to seek modification, etc., etc. The fact remains that OM dated, which is pursuant to the decision taken by the government at the appropriate level, was taken well prior to the coming into force of the Medical and Health Recruitment Board regulation and its subsequent amendment. Under such circumstances, this court is of the considered view that matter will require fresh consideration in the hands of the government for considering the case of the petitioner for regularization in terms of the OM dated. The government will examine the case of the petitioner as also the contention raised before this court that several incumbents who were regularized, who were given the benefit of regularization under the OM, did not fulfill the criteria, but nevertheless benefit of regularization was conferred. So where is the consideration regarding this in the impugn order? There is none. So mechanically, my lord, they have just rejected the case. So my humble submission is, my lord, in the meantime, my lord, I have been transferred out on the plea that my extension has not been, my service has not been extended. Now, since your lordship judgment is there to give us a consideration, and the consideration,
Appointed on PF
yes,
and you are praying for regularization.
yes, in terms of that OM,
There is the protection of court by way of an interim order.
yes,
It continues till the order of
yes,
release. is concerned.
yes.
Now you are transferred. where?
Now, I have been transferred to a position, my lord. No, my lord, actually what had happened, there is a transfer has been effected whereby some incumbents has been placed in our position. Now, as the stand of the department is, since your service is not extended, therefore you are no longer in service. That has been stated by
You
your
are
lord.
not transferred.
We are not transferred, but
Somebody
some
else is-
incumbent has been placed in our place.
Somebody else has been brought in by way of transfer.
So that is the position. And my lord, we are working as on date. There is no difficulty. We have filed an affidavit in reply where we have dealt with each and every contention raised by the respondent in their affidavit, which will show we are still working. And I can just place one or two communication, my lord. If your lordship would kindly come to page number. Please come to number 237, my lord. Now, my lord, the stand taken in the affidavit is that with effect from November 2023, we are no longer in service. Now, this is a communication of 2nd of January 2024 from so-and-so regarding assistance in document verification. With reference to the office letter, I have the honor to inform you that Mr. Pankaj Kakoti, Inspector of Drugs, Kamrup Metro, and so-and-so Hazarika Inspector is deputed for assistance in document verification for walk-in interview to be held on for the post of Registrar of Assam Pharmacy Council. So, my lord, this is a government communication.
When was the impugned order passed?
Of my lord.
Impugned order?
This impugned order was passed on 11/4/25. Then my lord will kindly come to page 239. This is on 5th of February 24 to both the petitioner. With reference to the subject cited above, you are hereby deputed for counting of postal ballot papers on 24 to 24 at 9 a.m. in Assam Pharmacy Council office as requested by the returning officer. So, my lord, there are, then please come to page 242. It is on 16th of July 24. Kindly see, my lord. So-and-so committee is hereby reconstituted as per the revised guideline received from the Government of Assam Health and Department by dated so-and-so. Serial number 11 is the petition. Drug Inspector, Kamrup Metro. Oh, my lord, we are very much on performing our duty. The contention raised that with effect from November 2023, we are not in service is not correct. Then at page number, my lord, 243, it's a communication of August 2024. With reference to the subject and letter cited above, I am directed to convey the approval of Government of Assam for attending 2nd National Congress Camp workshop at Mumbai, conducted so and so. And my lord, 5 and 6 are the two petitions. My humble submission is, my lord, it's a case where lordship would like to examine this, my lord, and lordship meanwhile will protect me, my lord, protect us. And
Yes.
prima facie, my lord, the consideration is total mechanical. They have ignored because at para 21, your lordship just clearly indicated that in the earlier exercise, you have even regularized persons who did not fulfill the criteria. Why similar benefits should not be extended? And the judgment, that short judgment which I have placed, my lord, the Supreme Court has clearly said, when it comes to regularization, you cannot just pick up somebody and leave out somebody. So there the principles of Article 14 has been applied. That is my with the lordship. Kind permission, can I friend?
Not a case that where I am going to rely upon one. I will rely upon all the judgments of Honorable Court regarding the interpretation of.
Just get it one. Circular had right, essentially one right. That if you are over it and you have not been, you have appeared or you have not been successful in like that. and you are not continuing by cases. Now, actually,
They are not over.
number two, did they appear? Did they appear?
They did not. That is the case. They got ample number of opportunities to appear and get their service regularized under the PF regulation. So Lordship will kindly come to page 51. Sorry. So this is not a case where it's a simple case of regularization of master role workers or ad hoc workers, where we'd like to rely upon Uma Devi and other cases. This is not that case. The case is on a totally different footing. So this is the appointment order.
Yeah.
Dated 10th November 2005.
Yes.
Subject to discharge of without notice and without assigning any reasons thereof, the following persons are appointed temporarily and until further orders as Inspector of Drugs for a period of 4 months under Regulation 3F. Lordship will kindly mark this. Regulation 3F of APSC Limitation of Functions Regulations 1951 in the scale of so and other allowances as admissible under the rules which effect from the date of taking over charge and posted at the places shown against it. The appointees should join in their services of posting within 15 days of this year, which appointment will be treated as cancelled. So they got this appointment. This is their entry. So they entered the service under Regulation 3F for a period of 4 months, which was subsequently from time to time was extended. And for last 1 year, I not extended anything. From November 2023, it has not been extended. They are basically continuing on the basis of interim order passed by the Congress Court. So,
Interim order passed
yes,
in
in
the
some other
earlier.
cases also, and here also, not to take coercive action, not to remove them. There is an existing interim order till today.
No, no interim order is passed, is it?
It is passed out.
Okay.
December, if I'm not wrong.
Benefit of some other order passed in connected writ petition?
No, these are standalone things. I'll say that. They have also just submitted their own, they are still continuing,
so
and this continuation,
There was some interim order passed in some other writ petition.
which is a connected case by the same item 2 and
So that benefit was extended.
that benefit was extended here also. There are same petitioners. So my humble submission is that this is the entry and PF regulation. So we have to. I have to go to the basics in this case. So their service is governed by a statute. So let us see what is this. Assam Public Service Commission Regulations 1951, page 78. If we are having the same book, it is the same book.
78.
78. So I am going to the heading. In exercise of the powers conferred by Article 318 of the Constitution of India, the Governor of Assam is pleased to make the following regulations as respect the composition and staff of Assam Public Service Commission, their tenure of office and conditions of service. So there everything, the condition of recruitment, condition of service, everything is governed by APSC Regulations 1951, which was made in exercise of the power under Article 308 that is relating to the public service. So this is how they entered service. Now let us go to 3F. Lordship will kindly come to page 95. Let us start 3 at page 92. it shall not be necessary for the commission to be consulted in matters relating to methods of recruitment to civil services and post or the suitability of the candidates for such appointment in the following cases. So there are 3-4 situations. So we are concerned with situation F, page 95. When an appointment is to be made by direct recruitment to a temporary post created in service, if it is necessary in the public interest that the appointment should be made immediately, and reference to the commission would cause undue delay, provided that if the post has been sanctioned for or is likely to last for more than 4 months, the commission shall, as soon as possible, be consulted in all matters mentioned in subclause 3 of Article 320 of the Constitution. So in certain situations when there is an urgency, then the government can straightway, without consulting APSC, can induct them, and that appointment order has to be basically for 4 months initially. And from time to time, and in the meantime, process has to be started for regular appointment also, for which consultation is required. So in their case, they entered service without there being consultation with APSC under a special emergency situation. So there, this is not the first time that a writ petitioner has come before this honorable court to seek regularization of services when their entry was under care. Series of division bench cases were there from 1993 onward till last year. Last year also, huge chunk of cases were disposed of by another coordinate bench. I will place all those judgments. Now, after this, their entry in 2005, several rounds of interviews had taken place, recruitment process, and they deliberately decided not to participate, knowing fully well that they are totally on ad hoc basis, initially for 4 months and subsequently from time to time, they are given. Their whole basis is this notification, OM of 2015. Page 86, 16th March 2015. My humble submission is that this OM note is for a limited purpose. The chart is also given. So may I read this notification, because their whole basis, they want to exert some right to be enforced on the basis of this note. My humble submission is that this notification is totally illegal, but however, it has lost its force. That is why there is no question for the government to withdraw it, because those persons who were named under this notification, they were all regularized. There is a chart also. In Health Department, 2 persons, page 90. Serial number 9, Health and Family Welfare Department, Rafiqur Ahmed and Satyendra Prasad. So they were inducted or regularized from Health and Family Welfare, from the Health and Family Welfare. Now, what is this all about? May I read it out? Appointment under Regulation 3F of APSC, Limitation of Functions Regulations 1951, and one-time measure for regularization of certain appointees. And Lordship will kindly mark this, although government is a continuous process. When the earlier regime, just in the final year of their governance, in 2015, issued this. Identically, they have done in Education Department also. I'm not naming any particular chief minister's name, but the earlier government, earlier dispensation, they did this, all this thing. Like in BTC also, just before their government was going to be over, 2 months ago in 2020, in March, lot of illegal appointments have taken place. During this time also, a lot of illegal activities has taken place. This is one classic example. The other classic example is the Education Department. Lordship remembers that. Lordship, I think, was handling those cases in the Education Department. But I am not trying to, because what they are trying to enforce is that a notification which is totally contrary to the statute. That's why I said Article 318 is resorted to frame the regulation of 1951. That has a statutory and constitutional backing. How can the executive bypass that and started all this process?
There is no scope of regularization under 3F. The High Court in umpteen number of cases has decided this issue. So I'll go to that. Before that, this notification, this OM which they are basing, and their whole foundation is on this. It is not tenable in any judicial. Had this been challenged, it would not have been. It would have been very difficult for us to protect this notification because this is totally bypassing or overriding the statute. So what they are asking now is that they are asking for negative equality. So the government has committed a mistake and they want to take advantage of that mistake. I will place judgments on negative equality. So Article 14 will not come here.
First, let us go.
Let us, yes, Lord. So appointment under Regulation 3F of APSC Limitations of Functions Regulations 1951 and one-time measure for regulation of 13 such appointed. Various departments of Government of Assam from time to time exercising power under Regulation 3F of APSC Limitation of Functions Regulation gave appointment to various candidates to tackle emergency situation faced by those departments. Many such candidates initially appointed for 4 months under Regulation 3F for continuing in the services year after year in ad hoc manner without regularization. All these candidates have already crossed the upper age limit specified for appearing in the interview test held by the APSC for the post that they are holding and therefore left with no chance to get regularized. These two writ petitioners, this is not the situation. They are within the age limit. Evidently, this situation has arisen mainly due to unwarranted exercise of power under regulations here by the department, failure on the part of APSC to hold interviews on timely manner, and also the failure on the part of the department to move APSC for regular recruitment. So these are the situations which was taken into consideration. As communicated by the concerned department, all these Regulation 3F appointees now under consideration are working in regular vacancies, mainly under various orders of the High Court and drawing their regular salaries as admissible. However, those cases where the incumbent concerned have not appeared in APSC test interview and whose cases are not are sub judice are outside the purview of this OM. So those who have not appeared, they are already out of this. So these gentlemen who read petition also were falling under this category. Even if we consider that this is a legally tenable OM. Government, after careful consideration of the matter, after taking into account of the views of Finance and Judicial Department in individual cases, the views offered by Advocate General Assam on the matter, and also the observations of the Supreme Court in Jacob and so, decided to lay down the following policy guidelines in matters of appointment under Regulation 3F and regularization of the existing 3F matters of appointment under Regulation 3F as aforesaid, so as to prevent emergence of any similar situation in future that may compel government to resort to such measures as this. Henceforth, no appointment shall be made under Regulation 3F without prior concurrence of Personnel and Finance Department and with approval of the Cabinet. Any such proposal as cleared by the State Cabinet for appointment under Regulation 3F shall have to pass through all the steps as laid down in the guidelines of OM dated 29th October 2001. Any fresh appointment under Regulation 3F after issue of this OM shall get 2 extensions of term and then their services shall stand automatically terminated. Personnel B department shall communicate the date of termination while allowing the extension of the second term. Next, all departments shall immediately work out the number of employees appointed under Regulation 3F working in the establishment under their control and take up with APSC for advertisement of the post within 3 months from the date of issue of this OM with intimation to the personnel department. The personnel B department shall not allow any further extension of the term of the employees appointed under Regulation 3F, which exceeds beyond 6 months from the date of issue of this OM, and will take up the matter with each of the department and APSC for advertisement of such post within the stipulated time.
there shall be no persons appointed under regulations PF with immediate effect from the first day of December 2015. In pursuant to this, there was recruitment in 2017, 2019, 2021. Okay. So for this post, regular appointment. So they were all eligible till I think 2019 or 2021. They skipped. Prior to 2015, I do not have the records just now. The list of employees appointed under number Roman 6 now. The list of employees appointed under regulation PF who have been considered here as an exceptional case and one-time measure for regulation as appended in Annexure A and who have rendered services to government varying from 9 years to 22 years and shall be regularized with immediate effect subject to the conditions that number 1, each such employee shall be regularized against the regular post which they are holding currently and drawing salaries therefrom. Each department whose name has been figured in the Annexure A against the name of the employee shall examine and verify the cases of these employees individually with reference to their eligibility in terms of the educational and other qualifications as required at the time of their initial appointment in regard to the post they are now holding. 3. On such verification, the department will issue order of regulation with immediate effect on the strength of this OM. Any such regularization, thus incumbents shall be eligible for the regular service benefit conditions as laid down in the respective service code. The seniority of the employees in their respective cadres will be counted with effect from the date of regularization. Roman 6. Their past services may be counted only for the purpose of calculation of pension benefits and for no other purposes. Roman 7 now. This is sought to be done as an exceptional case and one-time measure and shall not be taken to recourse in future. So there is a bar in that OM itself. So first they have to challenge this particular clause. Until and unless they cannot pick and choose a certain portion of this OM and leaving aside the other portion. So this line is very important, that this is sought to be done as an exceptional case and one-time measure and shall not be taken to recourse in future. So there's a self-inflicted restriction within this OM. Action taken report on this matter shall be subject to the Personnel B Department regularly on monthly basis till such time as there exists any PF appointees in the establishment under the department. And next page is the chart. Okay. So they have not annexed the complete chart, but however, serial number 9 is available. So these two gentlemen, Rafiqur Ahmed and Satyendra Prasad Borua, got the benefit of this OM because their age was over, number 1, and they are continuing for a certain number of years and they cannot participate in any other, and they have not appeared in the APSC interview who have sub judice, and their case is not under sub judice. So whatever criteria, rightly or wrongly inserted in this OM, they fulfill this criteria, and therefore the cases of these two persons, the writ petitioners herein, were not considered or taken into account. So their cases were sub judice also. They do not fulfill their cases. So their case is that they have age and they did not appear in spite of having opportunity. And after this OM also, and this OM is limited to this total number of about 2 numbers in the Health and Family Welfare Department. Nobody can, in addition to that, claim any benefit of this OM, and there is a specific condition which bars that it is a one-time exercise, it is an exceptional case, and nobody should take advantage of this OM in future. So first, if Lordship decides that this OM is the basis and on the basis of this OM, they are entitled for some relief, then this line will become the hurdle. Otherwise also, legally speaking, Lordship, this OM the cabinet do not have the power to give certain things which is not there in the statute. When the statute governs the overall recruitment conditions, service conditions, and overall service in public service. So, on the basis of this, 2 persons got the benefit, and now what they are trying to claim that 2 have got the benefit, so give the same benefit to us. So that is their case. They, number 1, do not fulfill the criteria as laid down in the OM of 2015. Number 1, my submission. Number 2 submission, that OM itself restricts that this kind of benefit cannot be given to any other persons in future. So they should have first challenged this particular clause in that OM before coming before this honorable court, or conjointly they could have challenged that OM along with this there. That under the present form, Lordship, in my humble submission, no case is made out in their favor on the basis of this OM. But I have other themes of argument. Now, what Lordship was pleased to decide in 2023, let me place this judgment also. Place 91. Lordship did not give them any benefit. Lordship then back the ball to our court to revisit the whole situation. And what we have done, we have revisited the whole situation and passed the speaking order on 11th of April 2025 on the basis of the judgment passed by this honorable court on 24th of November 2020. So let us now read this judgment, because they are trying to draw some observations from this judgment which is in their favor, whether that is actually correct or not. Let me place it out. Page 94, the judgment starts. The petitioner before this court is working as an inspector of drugs under the Health and Family Welfare Department. The petitioner was appointed as inspector of drugs by notification of 10th November 2005, and he joined the services on 16 November. The petitioner's appointment was under regulations CF. The petitioner was thereafter given extension by the competent authority by order dated 4 December 2006. Subsequently, the petitioner given in as much as 26 extensions to ad hoc appointments under regulations CF. The petitioners to the cadre of inspector of drugs is governed by the Assam Drugs Control Organization Service Rule 1994. Under Rule 5.2 of the said rule, the recruitment to the cadre of inspector shall be made by direct recruitment only. So, in addition, the PF can be brought into care. Rule 6. Prescribe the manner and method of procedure to be followed for recruitment to the post of inspector of drugs. In spite of several communications issued by the department to initiate the process of regular appointment, the same was not resorted to. It is stated that the appointment of the petitioner under regulations CF has cabinet approval of the state, and the same is recorded in the file number so and so. While the petitioner was serving, an office memorandum dated 16 March 2015 was issued by the government of Assam for regularization of certain appointments made under regulations CF of the APSC regulations 1951. The said process was adopted by the government of Assam as one-time measure for regularization of those employees who are continuing in ad hoc manner year after year without regularization by the said OM. It is stated that an exceptional case person who has rendered services to the government varying from 9 years to 22 years will be regularized. The petitioner duly represented before the competent authority claiming to be regularized under the provisions of the said OM dated 16.3. It is stated that the said office memorandum included the list of candidates who were regularized by the government in terms of the said OM. However, name of the petitioners was not found in the list, which was enclosed as an annexure A of the said office memorandum. Being agreed, he approached the court by filing WPC number 3383 of 2015. This court, while issuing notice by order dated 16/6/2015, was pleased to direct that one post of drug inspector shall be kept vacant until further orders. The interim order is still continued. So that point of time also there was some recruitment process in 2015. Therefore, Lordship directed that one post should be kept vacant. That means the process of fulfilling all the drug inspector posts was going on. It is submitted that in WPC 338P, IA being so and so was filed by the praying for taking a necessary action in terms of 15/2015. In the said IA, by order dated 30/3/2016, a coordinate branch of this court directed the Health and Family Welfare Department to take necessary action in respect of the petitioner on the OM dated 16/3/2015 and also directed to communicate the outcome of such decision to the court. It is stated that no objections was filed by the respondent in IA number so and so. Pursuant to the direction contained in IA, the department by order dated 25/4/2017 passed impugn order by which the petitioner's case along with others were rejected, held to be not suitable for consideration of regulation in terms of the OMD 16/2015. Being agreed by the said order, WPC 2812/2007 has been filed. In that situation also, prima facie, on the admitted fact, it is very clear that they had age in their side to participate in any recruitment process. So that is rightly done because in the other case also, direction was given that their case should be considered in terms of OM dated 16/2015. So admittedly and prima facie, Lordship, it is very clear. It was rightly rejected. Paragraph 4. The learned senior counsel for the petitioner submits that the impugned order dated 25/4/2017 was issued by the Health and Family Welfare Department deliberately refusing to consider the case of the petitioner, notwithstanding the decision of the state circulated by office OM dated 16/3/2015. Referring to the OM dated 16/3/2015, learned senior counsel for the petitioner submits that the said OM clearly reveals that the government has taken steps as an one-time measure for regularization of the services of those employees who are continuing in ad hoc manner year after year without regularization. Most all the candidates have crossed the upper age limit. So this is not correct, Lord, in my humble submission. And therefore cannot appear in an interview or test as may be held by APSC for the post, and therefore they are left with no chance to get regularization in the state post, and accordingly the government proceeded to take a decision by the OM dated 16/3/2015 seeking to regularize those candidates who had rendered services in ad hoc manner for several years. Under the said OM, there are certain clauses which are required to be satisfied before a person can be considered to be eligible for being regularized under the said notification. The learned senior counsel for the petitioner submits that notwithstanding the petitioner having satisfied the said condition, his name was not found to be included in the list of candidates appended to the OM dated 16/3/2015. This is an incorrect statement made before this honorable court, and Lordship was pleased to record that. Prima facie, Lordship, in 2015-2017, he had age, and this senior counsel made incorrect statement before this honorable court. To the best of the information of the petitioner, there are several candidates who did not fulfill one or all the conditions of the OM dated 16/3/2015. Yet their cases has been taken for consideration for regularization in the OM dated 16/3/2015. This submission was later on denied by them. The learned senior counsel for the petitioner also refers to the order dated 30/3/2016 passed in IA 962, whereby this court accepted the submission of the counsel of the applicants therein that the case of the applicant is identically placed like the petitioners in WPC so and so, so and so, so and so of 2015. The IA application was disposed of with a direction to the Health and Family Welfare Department to take necessary decision on the OM dated 16/3/2015. And the outcome of the decision be informed to the court, and the IA application was accordingly disposed of. It is further submitted by the learned senior counsel for the petitioner that the response that notwithstanding this order passed by the coordinate bench of the court, as well as the decision of the government by OM dated 16/3/2015, the case of the petitioner was not considered, and the department rejected his case by the impugned communication dated 25/4/2017. That time also he had age. In the impugned order dated 25/4/2017, the case of the petitioner was rejected on the ground that petitioner was not overaged, rightly done so, Lord. And that in spite opportunities were being available, the petitioner did not appear in APSC or interview, and consequently, he was outside the purview of the OM dated 16/2015. On these grounds, the representation of the petitioner was rejected. The learned senior counsel for the petitioner submitted these grounds are per se arbitrary and contrary to the decisions taken by the government at the highest level, as reflected in the OM dated 16/2015. The learned senior counsel for the petitioner submits that the two grounds on which the case of the petitioner was rejected, namely that he was not overaged and that he did not appear or participate in APSC interview or test, are not applicable at all to the petitioner in as much as his years of service rendered to the department. So he himself admits, he do not fulfill condition 1 and condition 2. He is only relying on the third condition, that is 9 to 22 years in service. The conditions as a whole, 120 also to be fulfilled as per that OM. But he himself submits that I fulfill only one criteria and other two criteria are not applicable to it. That is not the tenor or the meaning of that OM, even if you read it in plain language, simple language. The department did not proceed with any interview for filling up the post in regular manner. Consequently, there are no occasions for the petitioner to apply for and appear before the APSC. The failure of the department to hold necessary interview cannot be attributed to be a ground for rejection of the case of the petitioner. This is again a wrong submission. Ground on the case of the petitioner to be considered under OM dated 16/3/2015. That apart, it is clear from a bare perusal of the OM dated 16/3/2015 that it was a one-time measure and it was applicable to all government employees who are rendering service under ad hoc manner. The department has misread the criteria of the OM dated 16/3/2015. Under the said OM, the criteria for being considered are two, mainly that the incumbent concerned did not appear before the APSC or interview, and those cases are sub judice were not covered by the office memorandum. However, while rejecting the case of the petitioner by the impugned order dated 25/4/2017, the department relied on criteria which is not even prescribed in the OM, namely the criteria of overage. This is very much clear, Lord. I have read it. Lordship has also looked into it. Consequently, the OM impugned order dated 25/4/2017 being bad in law, the same should be interfered with, set aside, and was in support of his contention. The learned senior counsel, these are the judgments they have relied. Now, paragraph 5, what is the stand of the department? The learned counsel for the department strongly opposes the contention raised by the learned senior counsel for the petitioner. Relying on the affidavit filed by the department, the learned counsel for the respondent submits that it is an incorrect statement that the petitioner is overage. As per record, the petitioner was not overage as on the date of OM dated 16/3/2015 was issued. It is further submitted by the learned counsel for the respondent that the contention of the petitioner that there was no selection process or interviews conducted is totally incorrect. On oath, these are stated before this honorable court. Referring to the paragraphs made in the affidavit, the learned counsel for the respondent submits that the APSC by advertisement dated 26/10/2016 advertised for recruitment of 12 number of drug inspectors, and subsequently by another advertisement of 21/2018 recruitment for another 12 number of drug inspectors were issued. On a date when the advertisement 26/10/2016 was, a petitioner was 38 years 7 months 2 days, and on the subsequent advertisement of 21/2018, the petitioner was 40 years 5 months 0 days. On these averments made in the affidavit, the learned senior counsel for the petitioner submits that the contention of the petitioner that he was overaged or that there was no question of appearing in any interview in the APSC as no process of recruitment was initiated by the health department is completely incorrect and belied by the records available with the department. it is submitted that the petitioner deliberately did not apply for regular selection in the advertisement of 2016 and 2018, and therefore he could not have submitted that there was no opportunity for him to appear before the APSC for an interview. The petitioner deliberately avoided applying and appearing before the authorities concerned. The claims made by the writ petitioner are incorrect and same therefore does not merit any consideration, and the writ petitioner being devoid of merit should be dismissed. In fact, perjury has been committed by them. In rejoinder, the learned senior counsel for the petitioner submits that an affidavit in reply has been filed opposing the contention of the department. It is submitted by the learned senior counsel for the petitioner that there are a number of incumbents who had never appeared before the APSC or interview and yet got the benefit of regularization under the OM dated so and so. So they are now going to some different direction. Reference in this case may be made to the person at serial number 2 of the Health and Family Welfare Department who, according to the petitioner, never appeared in APSC interview or test. That apart, there are 3 other persons who had never appeared before any interview or test, and initially the names of these persons were inducted in the list appended in OM dated 16/3/2015. Therefore, they had approached this court by filing WPC so and so, so and so, so and so. The learned senior counsel for the petitioner submits that pursuant to the orders passed by this court by order dated 31/5/2016, the writ petitioners in these 3 writs were regularized by the Social Welfare Department, namely the department under which they were rendering service under 3F. The petitioner's case are similarly placed. He is not entitled to be considered for benefit of regulation as conferred by the OM dated 16/3/2015. Some Social Welfare Department is committing a mistake. I do not know what is the case there. All these things will not help him. And if their appointment was correct or incorrect, whether those persons were parties in this case, if it was an incorrect decision of the government would have thrown them out also. But that wrong decision in Social Welfare Department will not give any enforceable right to the petitioner's case. One is that OM is bad in law. With full responsibility, I am making a submission, because if you read all these judgments, Lordship will also have formed the same opinion. That cannot be done. They are rewriting the Assam Public Service Regulations and Functions 1951 by these officers. They cannot do it. It has to be done through legal process. So Article 161 has not given that authority to the government to bypass Article 380 or 309. Article 16 has a limited purpose. When there is a gray area, when there is a vacuum, in that situation, Article 162 can come and help any person or the department or the government. But when there is an existing law under Article 380, which is a very strong provision in the Constitution, as well as 309, in those situations, Article 162 cannot bypass. But that is also limited to those persons who are named in that list, Annexure or Appendix 1A, 2 persons. And that OM also says no further benefit can be given. It is a one-time exceptional situation. That benefit was given to a very limited number of persons.
The appointments are not under challenge.
That appointments are not under challenge. So, if I may continue, if we read the judgment, then the complete picture comes. Reading 3 lines from this paragraph, that paragraph will definitely not take us or lead to any particular situation from where Lordship could be pleased to take a decision. The learned counsel for the parties have been heard. Pleadings on the records have been carefully perused. Judgment cited at the case has been. The short case projected by the writ petitioner is that once the decision is taken by the government at the highest level and is reflected in OM dated 16/2015, there was no occasion for the department of the government to reject any benefit available to the petitioner under the OM dated 16/3/2015. In order to decide the contention, it is necessary to refer to the OM. So this OM Lordship was pleased to quote here. Coming to paragraph 9, 108.
The OM dated 16/3/2015 also encloses list of the candidates who are rendering 3 years services on ad hoc basis under the various departments of the state, including the Health and Family Welfare Department. There are 2 candidates whose name appeared in the said list under the Health and Family Welfare Department. It is also seen that by order dated 13/3/2016 passed in IA 962, on a submission made by counsel for the petitioner or applicant therein, that the case of the petitioners are similarly placed like the petitioners in WPC so and so, so and so, so and so. And an order similar to the one dated 24/2/2006 is required to be passed insofar as the petitioner is concerned. The court, on the basis of these submissions, directed the department to take necessary decision on the OM dated 16/3/2015, and the outcome of the decision was directed to be placed before the court at the next date fixed. It is also seen that the coordinate bench recorded that the counsel for the department did not object to the prayer made. That is the Social Welfare Department. On a pointed query by the court to the counsel for the respective parties, it was submitted before the court that the order dated 24/2/2016 had not been appealed against. The said order dated 24/2/2016 has attained finality. The said order is also expected below for continuance. May I read this order? Because it has some importance. Mr. B.K. Sharma, learned standing counsel, Social Welfare Department, submits that insofar as regulation of the service of the petitioners are concerned, consequential steps were initiated by the Social Welfare Department, and the relevant file was forwarded to the Personnel B Department. Personnel B Department has returned the file to the Social Welfare Department to take a decision on the OM dated 16/3/2015. Therefore, now the decision has to be taken by the Social Welfare Department. Let the department take a decision in this regard, and outcome of such decision should be informed to the court. It is expected by the next date decision by the Social Welfare Department be placed before the court. In terms of the said order dated 24/2/2016 passed in WPC 3767 and other connected matters, the concerned department, namely Social Welfare Department, therefore proceeded with the process of regulation of the petitioners in those petitions, and ultimately the order of regulation was issued in terms of the OM dated 16/3/2015, and the writ petition were subsequently withdrawn as been instructed in view of the relief being granted. So we do not know what is the factual situation in respect of those fees, whether they were overaged or not overaged, whether they are serving for the period which is required, and whether they have appeared in APSC or other recruitment process or not. We do not know. So Lordship has therefore sent it back to us. May I read it completely? While it is true that although these orders were passed by the Social Welfare Department, nevertheless, they are conjoined part of the government like Health and Family Welfare Department. The further contention of the Respondents' Council that the pursuant to the amendment to the Medical and Health Recruitment Board Regulations 2018 by notification dated 12/3/2018, whereby clause 17B was inserted. As per the said clause, officials are appointed to the post of Schedule 1 of this regulation under Regulation 3 of APSC and functions prior to coming in force of the Medical and Health Recruitment Board Amendment 2018 shall be deemed to be appointed under Regulation 17A, and their tenure of services can be extended under these regulations for such period required, including the period prior to coming before the regulation. The impugned order dated 24/5/2017 is also expected here, wherein Purna Sindhu Mudoi and Pankaj Kakoti were appointed as Inspector of Drugs, while order dated 10/11/2005 under Regulations 3F of the Assam Public Service Regulation 1951, and 10 years of their services were extended from time to time. Whereas Purna Sindhu and Pankaj Kakoti filed 2 writ petitions so and so before the High Court seeking intervention of the court in the matter of regularization of their services, where the Honorable Court filed 2 separate orders dated 10/6/2015 directed the government in Health and Family Welfare to keep 1 post vacant under further orders while referring to personnel department OM dated 16/3/2015. The department took steps accordingly by not sending two numbers of posts to APSC for regular appointment. So during that time, that process was already started. So APSC was under consultation. Whereas the Honorable Court on 30/3/2016 passed two orders directing the Health and Family Welfare Department to take decision on the basis of the Personnel Department OM dated 16/3/2015 regarding regulation of services of the afforded to inspectors of drugs and to let the court know about the decision. Whereas Personnel Department advised the matter as follows. The normal procedure is the department should examine the matter case to case basis and take up with APSC for advertisement of post for A regular appointments. Regulation through cabinet approval is not normal procedure which should be adopted only as the last resort and that too when there remains no alternative. So in by Tarun Gogoi's government in 2015 took recourse to this option, that cabinet decision for a limited number exceptional cases. But that cannot be a regular activity. Note 2, 13/12/2016, subject to fulfillment of conditions as stipulated by department dated 1st September 2016, tendered in your file numbers so and so, and following latest judgments rulings apex court may be relevant. Personnel B department conveys its no objection to the proposal subject to the conditions of that the incumbents are qualified, overage, and there is no scope for appearing before any interview to be conducted. So this lordship will kindly take the note 13/6/2016. They had age in 16 as well as 18's advertisement. We have given the figures on. Next page. Whereas there are no records available to indicate that Purna, Sindhu, Mudoy, and Pankaj Kakoti were appointed after the posts were advertised for open competition. Whereas conditions given by personnel department, I noted 13/12/2016 are in the line with the conditions laid down in personnel department OM dated 16/2000. Honorable Guwahati High Court has directed department to take a decision on the state OM. Whereas it was examined in the department whether the following conditions laid down by the personnel departments for consideration of regulation were made by Purna, Sindhu, Mudoy, and Pankaj Kakoti. The following are the findings. Whether the candidates are overage, as overage incumbents are eligible for consideration regulation as per the OM. The present age limit is 43 years for government employment for general category candidates as per personal OM dated 6 July 2016 dated 26/9/2016 date with OM dated 3/3/2016 which is relaxable by further 5 years in case of scheduled caste scheduled tribe candidate. The age of Purna and Pankaj as on 1/1/2017 are 37 years 3 months and 39 years 5 months respectively. Further, Purna, Sindhu, Mudoy belong to scheduled caste, so another 5 years is available. Thus, the incumbents are not overage. Next, whether incumbents have appeared in the APSC test interview, as incumbents have not appeared in APSC test interview, are outside the purview of OM. Presently, the advertisement issued by APSC for post of drug inspector issued by APSC was cancelled and it was proposed to issue press advertisement soon. Thus, it is concluded that Sri Purna, Sindhu, Mudoy, and Pankaj Kakoti have not appeared in the APSC test interview. Whereas it emerges that Purna, Sindhu, Mudoy, and Pankaj Kakoti do not inter alia fulfill two major eligibility criteria laid down in the personnel department OM dated 16/3/2015. Under the circumstances, it is decided that the matter of regulation of the Purna, Sindhu, and Pankaj Kakoti cannot be considered. This is in compliance of the Honorable Guwahati High Court order dated in so and so case. Upon due consideration of the rival contention as well as of the pleadings available on record, the short question is to be decided by this court whether the petitioner fulfills the conditions mentioned in OM dated 16/3/2015. Careful perusal of the OM dated 16/3/2015 reflects that there are two conditions which are prescribed if not fulfilled will exclude the consideration of the incumbent. These two conditions are as follows. The incumbent did not appear in APSC test or interview, and that there are cases are substituted. It is seen that the government, after due consideration and taking views of the Advocate General of the state, as well as the finance and fiscal department in individual cases, have decided to adopt this one-time policy for regularization of those officials working under 3F, barring two exceptions, all incumbents across various departments were to be considered. The OM dated 16/3/2015 revealed that the process for regulation which was adopted by the OM dated 16/3/2015 was taken into consideration the services rendered by regulation 3F years after years in ad hoc manner without regulation, as well as the upper limit prescribed for appearing in interviews, thereby leaving no opportunity to those candidates to get regularized to the said post. It was in view of this circumstances OM dated 16/3/2015 was brought in. In terms of the order dated 33/2016 IA 96, the department considered the case of the petitioners, however rejecting the same by their order dated 25/4/2017. In the said order, there are two grounds on which the petitioner's case along with orders were rejected, namely, the petitioners are not overaged and he did not appear before APSC test or interview. In the said impugned order dated 25/4/2017 or in the pleadings, there is no reference to the cabinet memorandum under which OM dated 16/3/2015 came to be issued. No materials have been placed before the court that the cases of the petitioners were duly considered at the relevant point of time. This lordship will kindly mark. Relevant point of that means 2015, not now in 2025. That the cases of the petitioners were duly considered at the relevant point in time while issuing the OM dated 16/3/2015, along with other similarly situated candidates whose names were found to have been considered for regularization in the list appended to the OM dated 16/3/2015. Whether the petitioner's case was placed before the competent authority for due consideration in terms of the OM dated 16/3/2015, and under what circumstances the cases of the petitioners were not considered compelling him to approach this court, has not been placed before the court by the respondent authority. What is not in dispute is that the OM dated 16/3/2015 is pursuant to a decision taken by the government at the appropriate level. The OM itself reflects that the views and concurrence of various departments, including finance and judicial department, as well as the opinion of the then Advocate General of the state were taken into consideration. The OM reflects that the views of the departments were taken in individual cases. The respondents have not placed before the court that at least so far as the employees of the health department who were regularized under the health and family welfare department satisfy the criteria as prescribed, and that others do not satisfy, which may or may not include the petitioners who are excluded from the list of candidates regularized under the OM dated 16/3/2008. It should be 2 instead of 3, because 2 persons were regularized from health and family welfare. The interim order dated 10/6/2015 passed by the court also sufficed. No application has been found to be filed by the respondent seeking vacation or alteration of the interim order, or bringing to the notice of the court that pursuant to the coming into force of the Medical and Health Recruitment Amendment Regulations 2018, the services of the petitioners are included under the state regulation. The Medical and Health Recruitment Regulations 2008 and its amendments are not actually in the present form. Consequently, there is no occasion for the court to refer to the validity of the correctness of this regulation at this point of time in time. However, what is noticed is that the initial appointment of the petitioners were made under regulations 3F of the APSC, and which have been on several occasions extended by the department without any demur. Consequently, the objection of the respondent that the services of the petitioners are currently under Medical and Health Recruitment Board Regulations 2018, as well as the amendment made thereunder, and therefore the tenure of extension of the petitioner's service will be dependent on the regulation, cannot be accepted as a ground to take away the rights of the petitioners accrued to the petitioner
petitioner under regulations 3F. The petitioner admittedly has been given several extensions over the year. There is no explanation as to whether the department considered giving continuous extension without considering the fact that the petitioner did not appear to the regular selection process. The government, being a model employer, is not expected to expect the services out of employees on ad hoc basis for several years without disclosing the reasons, and therefore refused to consider sympathetically the cases of the petitioner for regulation after having rendered services for several years. There is no dispute the contention raised by the petitioner that the petitioners in WPC 3767/2015 and other two connected petitioners were considered for regulation as their names could not be considered earlier because of the pending departmental proceedings. So their case, in my humble submission, fulfill those criteria as indicated from this line. That some departmental proceedings was pending against them. The impugn order, therefore, their situation is not identical with the situations of the present entity. The impugn order dated 25/4/2017 does not disclose the reasons as to whether the petitioner was allowed to continue on ad hoc and on application for vacating or modification of the interim order passed by this court, nor has any reasons been given before this court as to the failure of the respondents to seek modification, vacation of the interim order passed by this court in the present court. The fact remains that the OM dated 16/3/2015, which is pursuant to the decision of the government at the appropriate level, was taken well prior to coming into force of the Medical and Health Recruitment Board Regulations 2017 and its subsequent amendment. Under such circumstances, the court is of the considered view that the matter will require fresh considerations in the hand of the government for considering the cases of the petitioners for regularization in terms of the OM dated 16/3/2015. The government will examine the case of the petitioner as also the contention raised before this court that several incumbents were regularized who are given the benefits of regulation under OM 16/3/2015 did not fulfill the criteria, but nevertheless the benefit of it was conferred. The government will take into consideration the decisions taken by the government at the highest level that as a one-time measure. Steps were taken for regulation of the services of the government officials rendering service under regulation here, like the nowhere in the pleading or the impugned order is there any reference to suggest that at the time when the cases of other persons were considered by the government at the appropriate level, the petitioners was not who were rendering services under CF. In view of all of this above, the matter stands relegated to the respondent department to reconsider and deal with the case of the player for petitioners for consideration by consideration of all the attending facts, including the cases of the persons regularized under CF under various departments, including the Department of Health and Family Welfare. The respondent will take note of the fact that the government at the appropriate level has taken a conscious one-time measure for regularization of the incumbents who have entered ad hoc services under CF. The impugned order dated 25/4/2010 set aside. The matter is remanded back to the authority to re-decide the question for conferring the benefit of regularization in terms of OM dated 16/3/2015. The entire exercise shall be completed in a period of 90 days from the receipt of the certificate copy. So then next phase, the benefit of interest will continue for further period of 3 months till the respondent takes a decision in the matter in terms of our protection and allow disposal. So Lordship was pleased to send it back for a revisit. So we have revisited and passed the speaking order. So may I continue, Dr. P.R.? Yeah. On Thursday. If it is something I can do it tomorrow also. Not, but tomorrow is a miscellaneous day.
Yeah.
Yeah. Take your time.
It's Advocate General has opened his arguments. However, has remained inconclusive. Matter be listed on Thursday for further hearing.
Interim order 30th.
Interim order, if interim order passed will continue till the next.
My lord, stay is that the matter is in a nutshell is that recovery was made from him without notice any so-called. So he submitted representative why recovery has been made. They have replied that as a measure of penalty without following any procedure. This is the case. So no further recovery, meaning thereby they or unilaterally they from their own they are making recovery. That is what they.
All right, you that when you want.
Well, after 2 weeks, anything.
29.
My lord, okay.
You're for. No. You are not in the. Or You are in Tithi, but son appears.